Lawyers, has there ever been a time the opposing counsel accidentally proved your case for you and what happened? I had a hearing where the opposing party offered an updated contract that my client supposedly signed. Except it was a horrible copy and barely readable. Then he assured the judge that the new contract was exactly the same as the old contract. Except for the party name at the top. The original contract was in his mom's name. The new one in his name, and the date of the contract itself. He made that assurance multiple times. After he exhausted himself saying how everything was the same, I then pointed out to the judge that half the provisions were different and that my client had never signed that form. The judge asked if we were really accusing him of forging my client's signature. Since that's a serious accusation, I held up the guy's prior conviction for contract fraud and said I absolutely am. Your Honor. We won. Hands down. No further argument needed. Whoa. Those guys were either incredibly stupid or stupidly confident in their skills of trickery. I had a misdemeanor possession case I was defending. Client was driving his mom's car. He gets pulled over for playing the stereo too loud. There are pills in the center console. In a prescription pill bottle. The bottle has his mom's name on it. Client gets arrested and charged with possession of a controlled substance without a prescription. Case is obviously bullshit, but the dumbest DA I've ever met in my life won't dismiss. We go to trial. During closing arguments the DA says this case is a circumstantial evidence case. During my closing I slapped the jury instruction on the projector that says if a case is based on circumstantial evidence and there is one factual scenario that points to guilt and one that points to innocence, the jury must find in favor of the defendant and acquit. My client was acquitted. Edit. RIP my inbox. Also, there are some amazing discussions below. That makes me really happy. I responded to as many questions as I had time for. DM me if you have a legal question about this case. Lots of you are interested. So the jury instruction is Calcrim 224 if you want to look it up. I had to go to court over a financial cock-up when I was a student. Took advice from the university legal support team who said I didn't need a solicitor. So I went in alone. The judge didn't like this and postponed it for another date so I could prove I'd had more counsel first. The other party's solicitor caught me outside the court and said I didn't tell you this but, and pointed out a huge error in the financial paperwork that made it very obviously come out in my favor. Went back to legal support. Got confirmation that it was right. Went to the second hearing alone and got the entire thing thrown out. The other solicitor winked at me as he left. Saved me about you a cute 9k. Nice chapter. What a great act. That lawyer solicitor had every right to argue their case and try to win. But instead made sure a kid didn't get screwed. A+ person. Not a lawyer, but a relative of a retired prosecutor. Relative was working misdemeanor criminal court. Cases get called in alphabetical order. And two women named Catherine Smith and Catherine Smith were scheduled to have their hearings before the judge. Not their actual names. But you get the point. Both had similar crimes. But slightly different. So the bailiff announces the next case to the courtroom. Catherine Smith. For one count of possession of cocaine with the intention to sell. And one count of prostitution. So Catherine Smith stands up and indignantly cries. Whoa. Whoa. Just wait a second. Where the hell did the prostitution charge come from? I may deal crack. But I am not a WHRE. Easiest DRG dealing case my relative ever prosecuted. Actual lawyer here. From the full for a client file. Was interning at legal services after 1L. Doing discovery work for family law. My supervisor invited us to observe a hearing for our client to get a restraining order against her husband. At the hearing, the client discussed various times he threatened her. The man, representing himself, interrupted and said, "Judge, I never said any of those things. If I had, she wouldn't be standing here. Restraining order granted." You just know in the guy's head he was like, it's gonna be so badass when I say this. And you also know that when he now tells this story to his buddy, he says something totally different and then gets ducked over by the judge. Not a lawyer. But here's a story from the burbs. My buddy is in the middle of a situation like that right now. His psycho neighbor built a wall too high and doesn't have proper drainage on his property for the very small creek natural drainage in between their yards. My buddy hired an attorney as the psycho decided to sue him over it. My buddy's engineer that looked over the property noted not only did my buddy set his yard up right, but the neighbor created drainage problems. Neighbor hired his own engineer. That proved my buddy was correct. Now the guy is likely to go postal. Case was going to go to mediation. Since both engineers found fault with the psycho neighbor, my buddy decided he's going to take it to trial. Turned the tables a bit. Comma will post a follow-up if I can find this thread after the trial wraps. My favorite is a story from Jerry Spence. For those who don't know, he is a famous trial attorney. A witness on the stand was claiming that he had suffered injuries to his arm because of a city bus accident. Jerry asked him to demonstrate to the jury how far he can lift up his arm after the accident. The witness makes a feeble effort of lifting his arm. Then Jerry asks the witness to demonstrate to the jury how far he could lift up his arm before the accident. He lifts his arm much higher. The jury laughs. The case is over. Edit. Spelling. I am not a lawyer, but witnessed a pathologist win a case in court by destroying the defense's credibility. The question was over whether or not carbon monoxide poisoning could have caused certain signs of death in an individual. But the defense didn't study their chemistry very well and kept asking the pathologist whether carbon dioxide could have caused these signs. After thoroughly frustrating the defense by answering his questions incorrectly, the pathologist said very loudly, "Oh, I'm sorry. Did you mean carbon monoxide? Because that's a completely different thing." Completely destroyed the defense's credibility in front of the jury. They were done after that. So I guess the opposing counsel screwed himself by not picking up a book. Edit. For clarification, this is not the only reason that lawyer didn't win. There were a lot of other things that didn't work out in his favor. But those were technical things that he probably knew about ahead of time. This was a case where he was asking a question that he thought was going to work out in his favor. But it worked against him. Because he made a basic chemistry mistake that he honestly should have caught. Yeah. I know. He's not a scientist. But you don't have to be a scientist to remember the difference between those two things. Getting terminology correct is part of his job. It's not like anyone caught a felony charge solely because he said that one thing wrong. I worked as an intern for a lawyer. Construction law. In France. Are quite strict in regard to the neighboring of historical monuments. The city was denying a permit for heavy modification of the house of our clients. They were arguing that because you could see the house from the church's bell tower, modifications were impossible. As a support, they kindly linked us to a 360 picture from said bell tower. We, as kindly, pointed to them that our client's house was, indeed, not visible from the top of the church. Building permit was greenlit the following day. WTF. Anything that can be seen from the church bell's tower can never be renewed. That city will slowly disappear as buildings collapse in time. Not a lawyer, I know. But my parents were in a lawsuit where this happened. They owned a business. And on the either side of it were businesses as well. Their neighbor to the left sued us, claiming that we had been using their property without paying them or without permission. That we were essentially trying to adverse possess it. We got a surveyor to come in and the surveyor said that not only were we using all of our property, but we had been paying rent to them on about 20 feet that was also our property. Obviously they weren't happy. So they got their own surveyor, who gave us 50 feet. We won the lawsuit. Now their little patch of property has a rusty fence all around it with keep out signs everywhere. It's about 20 x 10 feet. When I first started, my firm had me on a case where the client claimed he lost because of ineffective assistance of counsel. Basically saying that the old lawyer didn't do his job. So we prepare an argument based on not asking the right questions, not communicating, etc. We think it's going to be a tough case, but not unwinnable. Then we get the response to our complaint where the old lawyer argues that he was only ineffective because he didn't have time to prepare for the case and only reviewed it the morning of the original trial. He had known about the case for months, by the way. The judge saw this, and during the trial we had essentially asked, isn't this the definition of ineffective counsel? Not giving enough time to your client? The silence from his side of the court was amazing. Needless to say, the trial didn't last much longer than that. Thanks opposing counsel. I guess you were ineffective for both of you. Accidentally proved? Not often. Made tactical errors? Often. Arguing a case on a voter recount in front of a judge. Judge says, I'm going with X. That's in my favor. So I shut up. Opposing counsel, in arguing a different point later, suddenly goes back to the earlier point and belabors it. Client, also a lawyer, says to me, don't say anything. I whisper back, don't worry, wasn't planning to. Judge begins rubbing his nose and looking irritated. After a few mins, cuts off opposing counsel, saying I already ruled on this point. Mr. Smith, me. Anything to add? I replied in the negative and won my motion. Would it have come out differently? I don't know. Did opposing counsel make it easier for me? Absolutely. My opposing counsel made some off-the-cuff remarks about how their client had to go to another remote office to get all the records they wanted to use against my client. That let me know the witness they were trying to use to introduce the records as evidence wasn't actually familiar with the records or the records keeping process. In the jurisdiction we were in, records were exception to hearsay rule. But you needed someone familiar with the creation and maintenance of the records to get them admitted. I attacked the witness qualifications to get the records admitted and ended up getting the records excluded. I then made a motion for a directed verdict on the grounds they couldn't prove the case without the records and won. All because the opposing counsel complained that their witnesses had to go way out of their way to get records for the court. Domestic violence case where the husband beat the wife senseless. Landlord tried to evict wife for breach of lease due to the beating. Landlord claimed wife violated lease terms by allowing police to be called to property and causing a disruption. My argument was that as a domestic violence victim, wife is covered under VOA and the property is HUD subsidized. Also MD law offers DV protections too. Landlord's counsel during his opening talked about how my client was beaten and the police were called in an ambulance, etc. I just stood there looking at him. When he finished, judge asked if I had anything to say. My response, no, Your Honor. I believe opposing counsel has said everything that needs to be said. Judge smiled and ruled in my client's favor. Landlord can't evict DV victim. My ex-girlfriend's father had a case where he brought in a decoy defendant. He then asked a key witness for the prosecution to identify the suspect in the middle of court. The witness turned and pointed to the decoy defendant, who was just a buddy of my ex-girlfriend's father and had nothing to do with the case. The witness was caught lying with his pants down and the whole thing was hilariously embarrassing for the prosecution. Turns out even if you're right, it's a huge no-no to trick witnesses like this. My ex-girlfriend's father had to go through an ethics investigation and was suspended from trying cases for a while. To those asking why it was a no-no, I have no idea, but apparently he violated a couple of court procedures and broke a state law. An actual lawyer might be able to comment more on it. I assume there's some law that the real defendant has to actually be at his own court date and you can't have a proxy maybe. When I first started practicing, I handled a custody case where my client, mom, had a problem with dad smoking around the kids. I asked him if he regularly smoked around the kids, to which he replied that he doesn't smoke tobacco, only weed in the house. Obviously this raised eyebrows as it is illegal in my state. He then went into a long diatribe about how he only follows the law of the streets. He actually said this, and doesn't recognize the authority of the court he was currently in front of. Needless to say, mom got full custody, especially after dad was arrested for going to the court services officer's house late at night and trying to kick her door in. Now. But work with lots. We deal with car accidents. And this particular girl was claiming severe whiplash and lower back injuries from a minor rear end accident. Some of her injuries were legitimate. But she was claiming that her life was ruined and she was unable to function in society. She worked as a physical therapy aide studying to become a PT. So she knew just what to say. But she didn't know what not to post on Facebook. She claimed she was in constant pain after the accident and couldn't go to the gym. The day after the accident. There's a pic of her lifting weights #accident can't hold me back. She claimed a month of lost wages. But there she is in a patient graduation from treatment photo on her work's website the week after TGE accident. She missed 0 days of work. She claimed that she couldn't travel anymore, and guess who had photos of Vegas strippers all over her Instagram for her sister's 21st birthday? She asked for $200 K. And she got $9 K for the legitimate injuries and mediation. As the mediator laughed at her Facebook feed. Plaintiff was claiming insurance money because he accidentally chopped off his fingers while cutting bamboo with a machete. And the insurance company, our client, refused to pay the insured amount. During the hearing, the plaintiff attorney began to demonstrate with a rolled up sheet of paper how his client was cutting the bamboo when the accident happened. No matter how he tried, he could not reproduce the position of the fingers with the alleged cut of the machete. The only possible match would be if the plaintiff had deliberately extended his fingers over a plain surface and hacked his own fingers. Based on this disastrous performance, the judge determined an expert opinion and later dismissed the case due to deliberate self-mutilation. Not a lawyer. But I had a legal dispute settled this way. Had a car crash in which both myself and the other party were driving towards each other. Both too quickly around a corner and crashed. A few minutes after the crash, another driver, who knew the other driver in the crash, arrived on the scene and offered to act as a witness, despite not having seen the crash. In this witness description of the event, they started off by describing the roads as totally blocked by hedges, with no visibility of the traffic ahead. They then went on to describe how they could see my driving as way too fast for the conditions, having seen me from miles ahead. Obviously called them on the contradiction and got the blame split 50/50. I was on jury duty once and a couple guys had robbed a place. So the guy who was robbed was up on the stand and their lawyer was doing the usual questions to clear everything up at the start, and when asked if he took an inventory before and after to show the value of what was missing, the guy just said, "Oh. No, whole case thrown out the window in about half an hour." Yeah. Most people don't have an inventory even for insurance purposes. That's the part where getting robbed house fires truly suck. Keep an inventory of your stuff. At the very least valuables. Pictures included. And back it up online.